abortion. Tennesseans a few years ago, you may recall in 2014, amended the state constitution to say that there is no right to an abortion under the Tennessee state constitution, and that issue is left up to the legislature, up to the General Assembly, which is basically the ruling of the U.S. Supreme Court today that that issue is now going to come to the states. Now, as a result of the ruling and its application specifically to Tennessee, I will quickly notify the Tennessee Code Commission that Roe and Casey have been overruled. That is required by statute. That has been adopted by the General Assembly. We will do that quickly, as I said. We've also filed an emergency motion with the Sixth Circuit. There's a case in front of the Sixth Circuit that we have been involved with for a number of years, challenging a 2019 law. And we are going to request that the injunction in that case be lifted. It involved a number of issues. One was a 48-hour waiting period, which we did win on that. There's a second issue on what we call the anti-discrimination provisions, which prohibits abortions when the physician knows that the abortion is being obtained on the basis of discrimination, race, sex, or Down syndrome diagnosis. Those provisions are not enjoined at this point. The timing provisions, however, of when an abortion can be obtained or rendered is enjoined at this point, and that's the reason for our emergency motion that we have filed with the Sixth Circuit, and we anticipate them hearing that quickly. To state the obvious, Dobbs is a momentous decision. Our republic is founded on the rule of law, and we accord respect to the Supremacy Clause, to the rulings of the U.S. Supreme Court when they are issues that agree with the laws of the state of Tennessee, which largely is the case in this instance. But we also follow the rule of law when it's not, and I was here in 2015 basically saying the same thing about the Obergefell decision and the Tanco, Tennessee decision. And those decisions did not agree with, I think, the view of most Tennesseans and the statute that we had in place. But in both this instance and that instance, the Supreme Court has ruled, and we are a republic founded on the rule of law, and we're going to we respect that. But more importantly, after nearly 50 years, today's decision sends it back down to the state, to the people of Tennessee to decide this issue where it should be, in my opinion. This is an issue of the court called a profound moral issue, and the policy discussions and issues are best served at the state level, in our opinion, and that's where it will be. And so the people of Tennessee, for the first time in 50 years, will have a chance to weigh in on this issue through their elected representatives. That's all I have to say, but I'm happy to try and answer any questions you may have for a while. I think the one woman behind you had the first one.
Nashville's district attorney has said that he will not prosecute doctors or women seeking abortions under this immunity law. Do you have any response to that statement?
Well, I would encourage him to look at the oath that he took for office. That's the only response I would have.
If he does, in fact, not prosecute women or doctors that are performing or having abortions in Davidson County, do you plan to step in?
I don't know that we've reached that point. Today, the decision has come down, so I'm not in a position to answer that.
Is there anything in Tennessee law, anything with result of this decision that would prohibit people from going to, women from going to other states or having groups take women to other states to obtain an abortion?
I'm not aware of anything, Andy. Interestingly, that was addressed in Judge Kavanaugh's concurrence. You might want to look at that.
I'm sorry, that
Yeah, Judge Kavanaugh actually addressed that particular issue in his concurrence.
I've got a question about your injunction or you asking them to stop the injunction for the fetal heartbeat law. Does the court have to take that up in any sort of timely manner, or does that have to happen today, or will it be like next week, or do they kind of have discretion on when they can discuss that?
They have discretion, and that's before the entire Sixth Circuit, so it's the en banc court. It's not the three-judge panel. We have actually been in touch with them, and we anticipate that will happen quickly. But we filed our motion, and I'm sure that the opposing party will have a chance to respond, and that we will, I think, have a chance to respond to their response.
And in the case they do lift the injunction, would that law take effect immediately?
Yes, it would. In the meantime, because the law, the Tennessee Human Rights, the Human Life Protection Act in Tennessee won't take effect until 30 days after the judgment comes down.
Is there any concern that pursuing two separate pathways to a widespread abortion ban is going to cause any confusion or problems for medical providers who are trying to determine what is now legal and what is not legal?
There may be a little bit of confusion in the interim, but we think it'll be pretty clear after that.
Okay, so you're going to notify the Tennessee Code Commission that Roe was, in case it were overruled quickly, but you haven't done that yet?
It just came down today, so we're going to do it quickly, as soon as we can.
Today?
As soon as we can. And we've got a couple of things that we need to look at to be sure it comports with the statute, but I would anticipate today or tomorrow, today or Monday,
And then
the latest.
30 days after that, the law would go into effect. That would
30 days after the judgment is issued is what the statute says.
The judgment of the
Supreme Court.
One of the lawmakers characterized your filing of the motion today as the equivalent of spiking a political football, and the timing of it as before asking the court to make a decision before the press conference as, quote, slimy. Any response to that?
No, not really. I mean, we're charged with representing the state. The state is evident and enforcing its laws, and I think the timing of things would be certainly in order.
Just so I'm clear, 30 days after the Supreme Court judgment is issued, the criminalization of all abortions, except for a few exceptions, will go into effect, not 30 days after you notify the
Correct.
Constitution.
Yeah, yeah.
So how
Yes,
does
sir.
the trigger law and the law that is currently tied up with the Sixth Circuit interact with each other? Doesn't the trigger law, isn't that more strict than the one that is currently the 6-week heartbeat bill?
Well, I guess that would be a point of controversy, but it's not. It's going to be pretty clear once that 30-day period expires, because that is the law that will take effect.
Okay, so you're hoping to have the law that is currently tied up take effect before that 30-day window?
Correct,
Okay.
correct.
which law?
The timing provisions that we've got before the Sixth Circuit. Yes,
But
ma'am.
the fetal heartbeat has nothing to do with the Sixth Circuit, correct?
Yeah, it does. It
Yeah,
does.
but-
Yes, that is. The timing provisions that I'm referring to are the fetal heartbeat, and then 6 weeks, 8 weeks, 10 weeks, up to. So. Yes, ma'am.
If a woman or a provider, is caught having an abortion or performing an abortion and was prosecuted, what does that look like? Like, what are the penalties they would face?
I don't think the woman would not be the subject of the prosecution. It would be the physician.
And what penalties would the physician prohibition phase?
Well, it would depend on what law is applicable, but under the, what is called the trigger law, it's a Class C felony.
So can you confirm that the state, you would not pursue prosecution of a woman who self-administers an abortion?
Well, our office is not vested with the original criminal jurisdiction in most situations, so we wouldn't be faced with that issue.
Do you think the law prevents local prosecutors from pursuing a woman who self-administers an abortion?
It depends on the law, but the trigger law that I just mentioned is designed at is directed to the provider, as most of them are. Okay, thank you very much.